Hello, and thank you for visiting Graphene Business Law. If you're watching this video on YouTube, go ahead and click on the red subscribe button down below. Graphene Business Law is your go-to platform for business law services for entrepreneurs and small and medium-sized business owners in Toronto and throughout Ontario. Here on YouTube, we'll be posting content regularly that speaks to your legal areas of interest as an entrepreneur or small or medium-sized business owner. My name is Pamela Mitani, and I'm the principal lawyer here at Graphene. Today's topic is shareholders agreements. I'll be providing a brief overview of what they are and when you might need one. If your business is structured in the form of a corporation, you likely need a shareholders agreement. Shareholders agreements can be in place as between yourself and the corporation, or between yourself and other shareholders of your corporation. If the business you own and operate has other shareholders who also have an interest in your business, it's a very good idea to have shareholders agreements in place. These agreements can ensure basal principles of fairness and integrity in the conduct of shareholders during the course of business. What's more is that a shareholders agreement can help you cover some of the gaps created by more mandated style governance pieces such as articles, bylaws, and governing statutes here in Ontario, including the Canada Business Corporations Act and the Business Corporations Act for Ontario specifically. I'll be scrolling down my list here to highlight some circumstances when you might need a shareholders agreement. It goes without saying that the needs for one depend on the needs of your business. However, I do want to reiterate that a good rule of thumb is to have that shareholders agreement in place. What we see, however, is that shareholders agreements are an especially good idea when you, as key shareholder or business owner and operator, are trying to establish shareholders' voting rights for your corporation, when you are trying to establish how shares may be transferred or issued for your corporation, when you're trying to establish restrictions on what directors can do in managing your business, when you're trying to establish what rights and options remain for other corporations following your insolvency, following your incapacity, or your death. This is important because your corporation has a separate life cycle from your own. In other words, following your passing or your incapacity or insolvency, whatever the case may be, your corporation is still counted as a separate entity that will continue to be run. And there are expectations on it in terms of the business dealings it's a part of, those bills it has to pay, bills going both in and out, employees it's giving direction to, and just the general affairs of your business still need to be carried out because that separate person is still in existence regardless of what's happening to you. Again, going down my list here, you might also need a shareholders agreement when you're establishing what happens to the shares of your private corporation following a breakdown in matrimonial conflict. Shares of your privately held corporation can be an asset that goes into the division of further assets during matrimonial conflicts. They can be used as support payments down the road. They can be used as one-time lump sum payments. And if your corporation is something that is integral to, if its success is integral to your identity as a person or to your dreams as a business owner, it's really worth considering a scenario where you might want to protect what happens to that business aside from what happens to your marriage or family circumstances. Also going down the list, establishing a shareholders agreement is generally good practice because it helps provide that hand of stability in your business in a way that's more private than what those other pieces of governing documents might entail, such as your articles of incorporation, which are accessible by the public. Content in your shareholders agreements is private content and can allow you to go more in depth into matters that matter most to you as a shareholder of your business. The life scenarios I've just outlined above can become quite complex rather quickly, so it is worth stating out loud that shareholders agreements can also become rather complex to draft and rather sophisticated. In order to navigate successfully shareholders agreements and their complexities, you should seek legal advice. Sections we often see lawyers working on for shareholders agreements include, but are not limited to, transfer rights, financial rights, insurance sections, buy and sell clauses, and what happens to your shares in those cases of incapacity or death or insolvency. There does exist an even more stringent form of shareholders agreement known as a unanimous shareholders agreement. If this is something that sounds of interest to you, you should definitely seek legal advice in drafting your unanimous shareholders agreement. Graphene Business Law was founded with your needs as a small and medium-sized business owner and operator in mind. It is just that, a business law firm. Here at Graphene Business Law, we are able to assist you with documents from the launch of your business to its growth to its conclusion. Specific to shareholders agreements, we can help you draft very strong shareholders agreements that best protect your interests as business owner and the interests of your business. You can contact us at any time, not only for help with shareholders agreements, but general incorporation agreements or corporate agreements, including how to incorporate, including vendor agreements, buy and sell agreements, non-disclosure agreements, non-competes, employment agreements, and that span of agreement having again to do with the launch of your business, its growth, and its conclusion should matters ever come to a state of bankruptcy or maybe happily selling your business. So you may contact us anytime by filling out the booking tool on our webpage, graphenebusinesslaw.ca. You may also email us at info@graphenebusinesslaw.ca or text us anytime 647-466-5985. Thank you for watching.